Good morning. Thank you for attending our panel. I'm Scott Wood, Emeritus Professor at Loyola Law School. One of our country's great crises that we face is overcrowded prisons. And although during the past 10 years there have been many efforts, many new laws to try to reduce mass incarceration, this crisis persists. We wonder whether new technology, innovative technology, could substantially aid in trying to reduce mass incarceration. So to discuss that question, we're very privileged to have two leaders in this effort of innovative technology and also in legal education and criminal justice reform. Susan F. Turner, professor and graduate director of the Department of Criminology, Law and Society at the University of California, Irvine, is with us. She also works as the director of the Center for Evidence-Based Corrections. And in that capacity, she's a leader in this innovative research, working closely with the California Department of Corrections and Rehabilitation to reduce mass incarceration. We're also very honored to have Professor Sam Pillsbury, Loyola Law School, who's had a distinguished career teaching criminal law, criminal procedure, and related courses at Loyola. In addition, Professor Pillsbury is an ordained Episcopal deacon and ministers at Los Angeles County Jail. Professor Pillsbury also has a new book on criminal justice reform entitled Imagining a Greater Justice. So I'd like you to join me in giving a warm welcome to our panelists. And we're going to begin with Professor Turner with her presentation, and then we'll have some discussion of the issues that arise. So
right, well,
thank you, Professor Turner.
I'm going to go over here so I don't turn my back on you when I'm speaking. And can you all hear me? Yes. Okay, great. Thank you. What I thought I would do here is just to provide just a few slides about risk assessment, and that's kind of the topic here, and what's it about, some of the risk assessment, the tool that primarily is used here in California, and a little bit about some of why it's being used or how it's being used with reducing the prison population, most recently with something called Prop 57. And my center has been working with the Department of Corrections for a number of years, and we provide evaluation assistance, technical assistance, and so we do it in a way that is as an impartial, unbiased university research team. And sometimes they like the results we come up with, and sometimes they don't. So you never know where the data is going to lead you. So I've got a little thing that won't move. Let's see. I'll use the panel. That's fine. So what I just wanted, this is my title, talk a little bit about risk assessment. And risk assessment or algorithms, you hear these things in the newspaper. You probably heard the ProPublica discussion a couple of years ago about a risk assessment tool being racially biased. Just FYI, the ProPublica analysis was flawed, but nobody seems to want to know too much about the natures of the problems with it. But there's a lot of concern nowadays about using risk assessment tools. I will tell you that we use risk assessment tools lots of places. What I'm going to do is talk about how we use it, a little bit for how risk figures into something else that's going on a lot across the country in the last 20 years called R&R, or risk needs responsivity. I'll talk about the CDCR tool, the algorithm that's used for risk prediction, and then the current policies that are being developed for using for the first time in I don't know how many decades, and something that used to be the third rail of correctional policy is letting people out early in the California Department of Corrections, which has been happening for the last couple of years. And it's something that's still being developed, the processes. So we use risk assessment tools in the justice system in lots of places. What's going to be on our ballot here in November 2020 is whether or not we as California citizens want to be thinking about changing our bail system. Do we want to move from a cash kind of a bail system to one that disadvantages individuals who don't have a lot of money, to something that is based on an actuarial or an algorithm? And so we're going to, it was passed by the legislature, but you can imagine that those involved in the bail industry were not so happy about it, and so now it's on pause till the voters decide. We use risk assessment tools in sentencing guidelines and have for many, many decades. We use it for parole, release, and revocation decisions across the country. We use it to assign probation caseloads. For example, you know, when a person comes on probation, there may be a risk assessment tool that says, okay, these are high-risk folks. We'll put them on a caseload that's fewer numbers for an officer so that they can kind of manage. So it's done for management purposes. And also it can be done for a priority for programming within primarily a prison system. And the programming priority will tie into some of the work I'll talk about risk needs and responsivity. But risk tools are not only common in the justice system, we use them every day. If we have sons who are young and they're beginning to be a driver, has anyone paid those high rates for their car insurance? It's based on an algorithm. We don't know exactly what it is because it's proprietary from the insurance companies, but it's a little bit based on gender, age, and zip code. So it's something that we've been doing for a long time. And work's been published on risk assessment since at least the 50s. So basically for 70 to 100 years we've been doing risk assessment. And what I want to start with is that the idea of using algorithms is in the press a lot lately, but it's been used substantially, as I mentioned, in these areas. But I wanted to show a situation here where it was used, developed to reduce, to determine when someone would come out of prison. And this thing is referred to as the salient factor score. This was developed for the federal system back when sentencing is indeterminate, to decide when is someone going to be ready to go out into the community after serving their sentence. It was based on a number of variables that are pretty interesting because these variables are ones that are often currently in risk assessment tools today, 50 years later. These tools generally include information about someone's prior record. And that is what bothers a lot of people. They feel that you shouldn't be using someone's past. But it has a number of factors that are kind of within the offender's control, maybe education and employment, and some factors about living with a spouse. So here, as an example of an algorithm that was used back then, these factors were placed together, but they were placed together in a matrix that not only considered their future risk of getting into trouble with the algorithm, but also took into account their offense. So one thing I think is important to know, and it was a simple system to add up the points. One thing that is important to know is that in many of these risk assessment algorithms, the risk assessment itself is not the only thing used to make a decision about someone. And even, for example, here I'll mention in California, a risk assessment tool is not the only thing that's used to decide if someone can be let out of prison early. So, and many of the tools, for sentencing tools, and this is for a parole release tool, consider two dimensions. They consider the severity of the offense. So, people have to make a determination, put things in buckets, what are serious offenses and what are not serious offenses. And they then consider a person's score. Those items were added up, and basically, it's an interesting scale because the higher, the better it is. Usually it's the higher, it's the worse. And with this salient factor score, these are the months that people, were the suggested ranges for people to serve in prison. So for example, someone who had a very good score and had a fairly low level seriousness, the months in prison were recommended to be under 4. At the contrast, if you had a very serious offense and somebody had a very poor score, on those factors. Had a lot of prior record. You know, they didn't have employment. They had a lot of drug use. Their release plan into the community didn't look so good. A recommendation was over 180 months. So when risk tools were used, even in the 70s, they had a component not only of sort of a cold, hard actuarial tool, but also something that has to do perhaps with just desserts. These are the kinds of, we are concerned about the nature of the offense. So we've been doing this for a long time, and we've been using actuarial tools. So that's kind of the first point I wanted to make. And the concept of risk, though, has gotten, the idea of risk has gotten sort of leverage and I would say importance in a new way of working with offenders that's more based on a rehabilitation model. So many of you know that, this is what I do with the students. I talk about fashion going in and out. So, you know, before the 70s, we kind of believed in rehabilitation, and then toward the 80s and 90s, we got a real get tough kind of mentality, and we thought rehabilitation was dead. And then there was this voice in the wilderness of Canada with some of the psychologists that said, hey, you know, we really do believe that people can change. And if you really think about the psychology of things, there's a method that we can think is effective for working with offenders, and it's called the R&R, or the risk needs responsivity approach. And so risk also figures into this, and it goes a little bit something like this. If we want to change people's behavior and we're concerned with public safety, what we want to do is focus on the people who are at high risk of recidivism. And that salient factor score is one way to do it. We want to, the second factor, responsivity, will glitch every spell check you ever have. But it's a funny word, but basically means that when we work with offenders or individuals, we want to make sure that how we teach them is in a way that they can get something out of it. And generally that translates into a cognitive behavioral approach. And that when we do treatment, we want to focus on the things the offender needs that have been shown to be related to recidivism. So self-esteem is something that many people think is something we should focus on to help individuals in this world make behavioral changes. It's really not sort of one of what the research had shown were these 8 risk factors and needs, which are important correlates of criminal behavior. So the risk needs responsivity model was actually pretty much a sea change coming into play a lot in the 90s. Often in probation departments, I think, because in many ways they're more likely to adopt a rehabilitation model. But it's been sort of imported down from Canada and is in use as well in many jurisdictions across the United States. With the R&R model, they posit 8 major risk factors. The first one is an history of antisocial behavior. That kind of sounds like our salient factor score. That's our sort of predicted probability of arrest. But other things impact someone's sort of ability or willingness to do well after release primarily. If they have an antisocial personality pattern, that's known as a risk factor. If they have antisocial cognition, which kind of translates into the way they perceive the world is as if they're the victim, people are out there for the taking, they have sort of criminal attitudes. If you have antisocial associates, means you hang with bad folk, right? So think social learning, you learn behaviors that are not law-abiding. These are referred to as the big 4. And then there are these other 4 risk factors that the literature has shown are related to recidivism or doing poorly in the community. Family and or marital, meaning if you've got strong family ties or a good relationship, whether you're doing well in school and or work, whether you have leisure activities, so it sort of harkens back to you don't want people idle, and substance abuse. So these are the factors that this risk needs and responsivity model say these are the things that should be targeted. Now you can't really target and change their prior record, but we can work on things such as getting them skills and work. We can work on substance abuse. Have them learn how to hang with pro-social friends. And so this model is a model now that is even being sort of incorporated into prison systems as well, which marks, I think, a move toward a more the swinging back now to a little bit more rehabilitation in the thinking. Now, where does this sort of, yeah?
Can I ask a question? I see substance abuse is on there as a factor, but I don't see mental
Health is not on there.
Is there, can you comment? I mean, antisocial might get to some sort of mental feeding into that area, but...
It's actually an interesting area, because mental health or mental illness by itself, as the research shows, is not a factor that adds to it. But people with mental illness have more of these factors. They have more problems with school or work. They have more problems with family relations. Some of the work that Jen Scheme has done with talking with probationers and trying to understand when they do crime is that very little of the criminal behavior they do is actually at that moment a result of the mental illness problem. It's a result of some other sort of related problem. So yeah, and that's the one that people pick up and they go, it's missing, right? And that's kind of hard to wrap your head around, I think, in some ways. But current literature suggests that the issue with mental illness is that you've got a lot of other deficits, and it's those deficits that are causing the problem. It's not to say you shouldn't have mental health treatment, because that'll help get your health conditions under control. But in order to change your criminal behavior, you need to address some of these other factors. So here's the R&R kind of mantra. And I think this is, in some ways, attractive because it's pretty simple. You want to focus on the highest risk offenders. And research coming out of Cincinnati and Ed Latessa suggests you don't want to put it on low risk offenders, because if you put a lot of low risk offenders in with a bunch of individuals who have higher risk factors, that's not a good thing. And also, if you do intensive treatment on people who don't need it, it may backfire. So where does the tool come in? The tool comes in here. You've got to have some kind of a tool to figure out who are the higher risk offenders. And this risk means risk to recidivism. You want to use methods that are responsive to the learning style. So you want to use cognitive behavioral strategies and target criminogenic risk factors, things that can be changed. So you want to target the factors up there that you can make a change in. Give them substance abuse treatment or understand family relations. So this is how the R&R model suggests that you would change behavior. And in fact, well, there's another slide here. I'll show you how CDCR used it. So if we got to have a model that uses risk needs and responsivity, what are we going to do for a risk assessment tool? Well, and this is where we turn now to CDCR. So we've gone through what risk assessment is, the R&R model, and now we're coming here to the prison system. Now, the prison system, as many of you know, and as California was the leader, but we're up almost at 170,000 folks in prison around 2008. And we've been coming down the last 10 years through a variety of policy measures. But about that time, before something called public safety realignment came and made the biggest decrease, there was a concern that the Department of Correction, they didn't really have any kind of risk assessment tool to help them in what they did. And so this risk assessment tool, we refer to it as the CSRA, although the folks on the ground often call it the CASRA, was the desire by the Department of Corrections, who up to 2007 had no risk assessment tool, despite the fact that you see risk assessment tools here were back in the 70s, to figure out how to make a tool. And so my center at the University of California, Irvine, worked with them to develop a tool. And it's interesting how organizations work. We say, well, what kind of tool you want? Well, we got how about Washington? They're close by. They've got a tool. We're kind of West Coast. They're kind of West Coast. Let's take a look at their tool. So this was basically a replication of a tool that had been in use and developed in Washington State. And it's one that we helped develop more than 10 years ago. Currently, we're doing some refinements for them. It uses what's referred to as static items, and this is where people can get kind of, I would say, a knee-jerk or sort of a philosophical. I don't mean that they're the same, but they say this and they go, oh no, this is tough because we're just going to consider someone's prior record and we're going to make some prediction based on just their prior record. Turns out that you can do this as well with prior record as with some of these other softer items that we saw up there. So what CDCR had was a kind of a problem. They had a system where they could manually interview people to get a risk assessment tool, but they had almost 170,000 people, and they needed something that could be done quickly. 170,000 in prison, and they had the folks in parole, which was like another 120. So they had basically almost 300,000 people that they needed to come up with a risk tool. And so for them, this is an automated tool that gets feeds from the California Department of Justice, rap sheets, criminal history records, and goes through the algorithm, comes in, goes through the algorithm, and then processes for every single person in the system a risk assessment score. So from their point of view, this was something that helped them because they were able to have it across everybody and not just the people who could, be there with a hand-done kind of interview instrument. And so it was the scale of the problem they had that I think was one of the reasons why they felt that an automated tool was important. So now, everyone who was under the California Department of Corrections has a score. Now, in the years that I've continued working with CDCR, one of the things that we get is people want to know, what does my score look like? And of course, as researchers, we can't provide that. But I think that even the public wants to know, what's behind the tool. It's not it's actually not our job to be, providing it to them. But it is something that still is a question: what's behind the tool? So what are the items? Well, here's the items, and these may look somewhat similar to the first instrument I put up on there, the salient factor score. Age at release, gender, it does not contain anything about race, ethnicity. The number of felony sentences, and number of ways we go through the rap sheet and collect and score certain types of prior offenses, either felonies or misdemeanors. What happens is that a person is placed into one of three buckets: a low-risk bucket or category, a moderate, and then there are three high-risk groups: one for drugs, one for property, and one for high-risk violent. And often there's the focus that we all are worried about is the folks who are in the high-risk violent. So over the years, the use of the CSRA within the department has, I think, waned and waned. Originally, and this is the best version I can get of this, but originally in 2007 there was a concerted effort to have what's referred to as a logic model for CDCR. People would come into the system, they would do a risk assessment, and then for the high and moderate risk people, they would move on to assessments for the criminogenic needs. So the R&R model was built into here. That if they were low risk, they didn't get provided treatment. But if they were high or moderate risk, they went further to sort of an assessment of their criminogenic needs. And then those who had criminogenic needs would then go to programming within CDCR to address that. So it was kind of a logical approach to incorporating the risk needs responsivity into CDCR, plus the use of an automated risk tool. Now so here's the needs, and then people would meet with a case plan and they'd get treatment. Then the feedback was that people would get out, you'd assess to see how well they did, and then you try to improve the process. I'm not sure that this thing ever really got implemented as originally designed by the work team in 2007. But it's an example where you can see how both risk assessment and a risk needs responsivity approach were incorporated into a model. So now, I'll just end up here. So where are we now? Well, the CSRA was used for a while for trying to determine who would get programming services, but what invariably happened is that you know, people kind of got first come, first serve and wasn't triaged as well as it should have been. And it could be used, it was used for some things having to do with parole supervision. But the question now, I think that's facing CDCR, as they've come down with their prison population, they are now trying to work on how to implement, I call it sort of like the third hit at it, with realignment and Prop 47 and now Prop 57. Prop 57 now is the latest legislation which is trying to reduce the prison population so that the three-judge panel will kind of give us the final checkoff. But what this proposition has done is it said, okay, now for people who are nonviolent offenders, for people who have served their primary term, and they may have some added time, let's go before the parole board and decide whether or not these people can be released early. As I mentioned earlier, this used to be the third rail of politics. This would just, you know, departments of corrections would, you know, if someone was released early and something happened, a Willie Horton kind of event, all kinds of havoc would happen. But now here we are in California talking about this openly. And I got the latest information I could get from the Board of Parole hearings about, well, how are they handling this? So the way they're handling this is not just with what I think some people think is an algorithm, the CSRA cold and hard, and you know, if you score high, you have to stay in, is that they have actually been doing a process which, again, comes from our friends north of the border, from Ralph Sarin, who is from Canada. And they have developed something called a structured decision model. And currently, this is consistent with the regs and the board. But what it basically does is it once again, is using a number of areas to decide whether or not someone should be okay to go out. And remember, these are property offenders who served the length for their primary term. So they've already done time and they're not violent. You can see the areas up there. There's the one on the top. That's the one that gives us a little bit of angst. Criminal and parole history. That's where currently they're not using the CSRA, but there's talk about that. But through each of these areas, the parole board makes a determination, it's kind of written up, about whether or not there's aggravated or mitigating circumstances for these different areas. Whether people are, and these look like factors we often know are made in parole decisions. Their behavior, the programming, do they look like they've changed? Do they have a good release plan when they get out? And then sort of, we always have to put in extras. But where we are now with California is that their current system is pretty manual for this Prop 57. They are going to need to do something to move it along because there's a backlog of cases now with Prop 57. And some of the discussions that I was asked to go up there and talk about was, you know, could we put the CSRA up there to help with that criminal and history? So once again, the idea of using an actuarial tool has, you know, become to be important within the CDCR, but it's not and it has never been the sole factor that's used to make any decision they have there. So that's just kind of a quick run through of, you know, risk assessment, tools, what tools can do. There's a whole lot of issues that I'm sure we'll get into about false positives and false negatives, which are just, I mean, tough things that we need to think about. Whether or not these tools are biased, they can be biased because the system, particularly in some counties, is more likely to arrest people of color than not. And, you know, what kind of, how good is the data that we're using? So there's a lot of other issues that go with risk assessment. But I would say that even within CDCR, I think that there's a recognition that a risk assessment tool by itself is not going to be the answer to some of the things that, the decisions that they need to make. So that's kind of my background. Yeah.
Just to clarify, in these lists, in this list, the risk assessment tool is in one of these points?
The top one,
in addition to them?
the tool is not in any of them. I actually have the form that they use. You can, this is how they do it. It's just sort of a paragraph to take a look at, does a person have a history that gives you pause? So it's more of a clinical kind of a thing.
Criminal and parole history. It's that.
Yeah.
That's what the risk assessment is.
That's where they're talking about maybe putting the risk assessment
Got it.
there rather than this little paragraph.
Thank you, Professor, for that overview. I'd like to invite Professor Pillsbury now to offer some thoughts and responses to the presentation.
Thank you, Scott. Thank you, Susan. So lots of different thoughts here, and I'm just offering a few from really very different perspectives. So in law, one of the things that we worry about a lot, we talk about a lot, is how we ask the question. How do we frame the question? And I just want to say a few things about the framing here. And first I'll start off with what seems to me to be a real positive. In California, and I think in many places, parole decisions, if we just focus on that, discretionary decisions about whether to let somebody out on parole. These are individuals who have gotten a for-life sentence where they're eligible for suitability for parole. Those decisions have traditionally been very strongly driven by offense of conviction. And so they're very much record-based. That's what it seems to be occurring. So the parole board starts with the record, the file, of this person's record of criminal conviction and disciplinary proceedings in the prison. And that, particularly if it's a bad crime, a particularly heinous homicide of some kind, regardless of how long it was ago or regardless of behavior in prison since, it is really still powerfully based on that original offense. And that's contrary to the way the law is written. The way the parole law is written is about present danger to the public, and anything that will get us off from just that fixation, which is also very true of our basic legal system, which is that a judicial and prosecutorial perspective on this is very much about what did you do, how bad was that offense, and make assumptions on that following. And that is often not valid. So, for example, if we have a young person, could have been 16 or 17, tried as an adult, could be 19 or 20, and that involvement was a homicide, and they're now 35, that original offense really doesn't give us much predictive power for public safety today. But the public perspective on that is very different, and for people who've been in law enforcement and prosecution, they still have a very much, well, that's the crime of conviction. A more sensible, let's look at what this person's real risk is, looking at all of the things we know that make people likely to recidivate, that seems sensible. Lots of issues, obviously, about making really, really important decisions about how we deal with people based on an algorithm do arise. Questions of fairness, questions of respect for individuality are really important questions. So, are we, let me suggest a different kind of a framing here. When we're looking at this as a problem in people in prison, people on parole, we're looking at this as a problem of them. They have the problem. How do we change their behavior? And when we flip this around a little bit and think about putting ourselves on the other side of this, if we have a particular issue, what does it feel like to have the government describing us as a problem that needs to be fixed and a set of behaviors that need to be modified? Now, those are all things that we definitely have to address, but there are all kinds of ways in which that I think should make us cringe a little bit, because we're talking about people and we're talking about their lives, and let me suggest a different way of framing. If we are not just framing this according to our safety from their threat, but we're thinking about this as if we imagine justice in a different way, if we were to imagine justice as an ideal of belonging, that everyone should belong to community, then we see what we're doing with punishment and incarceration in a different way. We may see this as a perhaps necessary decision that no, right now you can't be with us in free society by virtue of the severity of what you have done. That's a wrong that needs to be recognized by punishment, and also you may be simply too dangerous to be out there. But the larger goal should be, if possible, a return to community that is real belonging. And that can be made more difficult by any labeling of a person as X danger. And one of our difficulties, of course, is not just in deciding who should be released, but what happens then? What happens then? Do we continue to have our essential policy driven by a risk score at all times, in which case the person is, that reduced to that thing? So I think that there is very much a place for this R-in-R kind of assessment, but we have to be very careful about how we're using it. Criminal justice systems always default to the cheapest and politically safest. And so we have to anticipate that any algorithmic tool was going to be used that way. What's the cheapest way to run our prison system? What's the cheapest way to run parole? And what's the way that's going to reduce the most amount of political risk? Because, of course, all of this occurs in a larger political context, which is never going to go away. The more you get professionalized in criminal justice, the more you get this temptation to sort of say, well, we know what's going on and they out there don't, and the more we can just keep them out of our decision making, the better. But it never works that way. When we changed from a very indeterminate sentencing process in the 70s to a very determinate sentencing process, it was all about trying to get this discrimination out and be very regularized in our judgments, but it became a vehicle for, well, it's a really good way to get more and more people in prison because that's what the public wants. So complicated picture, and I am, by my comments, trying to complicate it more because I think that we have to have a way of making our decision process respectful and fair and consistent with belonging. I'll leave in my comments here with one more point. So you look at all that list of all of that antisocial stuff, and that antisocial stuff is absolutely real, and it is absolutely part of being able to predict. So somebody's in a gang, that's a big thing, and that makes that person more of a risk factor. Absolutely does. But maybe we should think just a little bit about why that person became part of a gang, and the ways in which all that antisocial thinking and behavior comes from the way that society gave them or didn't give them a place in community originally. So there's a place in this where we as a society are part of creating the conditions which then produce the antisocial attitudes, antisocial behavior. I mean, it might be actually kind of logical and reasonable in certain places and times in your life to say, they're out to screw me, I'm going to screw them, and that becomes a defense, a survival mechanism, and it is ultimately self-destructive and other-destructive, and we want to address it. But just saying that it's all their problem and none of it's our problem seems to be missing a larger part of what we should be about.
Thank you, Sam. So one of the points that struck me was this potential or real conflict between the model and respect for the individual person. So would you like to speak to that, Susan?
Well, yes, I'd be happy to. One of the first points I want to make, however, is when I'm talking about risk assessment, that's kind of a micro issue, whereas we're at a macro problem where our communities are not where they need to be so many of them have young males who are missing and they have a loss of social capital. So the risk assessment is not going to fix that. I mean, so this, in some ways, I'm not saying that risk assessment is going to solve some of these bigger problems. But having to do with respect, individual respect, and a risk assessment tool, I think it seems cold and hard, and I'm not necessarily, it's not that I'm an advocate for how to use risk assessment, except that there's a couple of things. That risk assessment is generally more accurate than a clinical judgment, and it's been proven to be more accurate for at least 70 years. So if somebody's going to try to understand someone's risk, maybe in the macro, that you got to do it in a way that's not totally flawed. And so what risk assessment actuarial models may be doing is replacing something where a probation officer with 30 years says, well, I know your type, I know the look on your face, I know you're going to be XY kind of person. So that's kind of a micro kind of an issue. With the idea with respect, though, I think is what I've tried to mention is that a risk assessment tool should never be used by itself in a decision for what you're trying to do. And I think that we need to understand that. So, for example, with way back before realignment, there was a concern about, well, maybe we can let some people go out on something called summary parole so that they could go into the community. They're the lower risk in the RNL model, and they could get back with their lives and not be sort of under a correctional system that would violate you. So that, and for that decision, one of them was risk, but one of them was, you know, are you part of a gang? Do you want to do this? Would you sign the piece of paper? Did you do well in prison? So that some of these other factors, what I would hope get at respect. But the respect, I think, is a macro issue with the whole system. We don't have a very respectful criminal justice system to begin with, and we have a system that is, you know, often retributive because we focus on the offense, particularly for our lifers. Our lifers have some of the lowest recidivism rates out there, and focusing on that is certainly not respectful, and we focus on the crime. So my answer is complicated and kind of probably sounds a little squirrely too. I wouldn't say that risk assessment by itself is not respectful. I think it's respectful of a couple of things. One, that if you're trying to understand someone's future behavior, these things are better than chance, they're better than clinical. But even the issue is, how are we going to use risk of an offender in any kind of decision that we're going to have? And part of that, I think, is our communities. When we run some of these risk models, we put the county and the zip code of where people were in there. And those things, just like with health disparities around here, if you have a zip code where you're raised in, you know, a high SES, you're born in a high SES zip code, you live longer. So the respect comes, I think, from the bigger problem we have in society of how we deal with people who don't follow the rules. So certainly we don't want to use a risk tool as just a cold hard thing, and you can't use anything else. But it's the question of fairness, I think, and there's some issues with fairness on risk tools I can talk about. But respect, I kind of see as an issue bigger than just a risk tool. I think it's a terrible problem that we have, that we are not respectful. And I can tell you we're not respectful in Los Angeles because African Americans get arrested a whole lot longer. We looked at the risk tool here. They have incredible overrepresentation in arrests in LA County, which suggests that some of the issue that we've got is that the police are practicing a different kind of public safety in different communities in the county than in others. So I perfectly agree. I just wonder that, you know, if we've got this prosecutorial kind of base system, that, you know, it isn't one that really has a lot of respect, I think, for people and for communities. So it's tough. I don't know if that helped at all answer your question.
Yeah. Let me turn to a more positive question, I think, and then I'd like to open it up to the questions that any of you may have. But a question for both of you: what gives you hope about reducing mass incarceration as you consider the work you've done and the long-standing relationship you've had with the state's prison system? As you look forward, what gives you hope?
Well, working with the prison system, I don't know how much hope that gives me, but I do have hope on a couple of things. I think people are finally beginning to realize that to reduce the system, that we have to stop, I go like this to my class, we got to stop nibbling around the edges. We have nibbled around the edges in California with, you know, changing some felonies to misdemeanors, and maybe this Prop 57, but we are not, that curve that went up into 2009 before it started to come down, just comes down a little bit. My hope is that people are really now starting to say, this problem is not going to be solved by, around the edges. We've got to really seriously talk about what are we going to be doing with violent crimes in our country. And so I think what I'm happy is that I think people are beginning to see the focus is going to be really, it's got to be really big. I'm also hopeful, which is that, if we can continue to get the message across that stopping the pipeline before it gets to the prison doors is really where we need to be putting in education and Head Start programs and early intervention. So, which is not the work I do, but I follow the work, and I think that's what gives me hope, is that we see where we should be focusing a little bit better, and some of the things we're doing now are not going to get us where we need to go.
What gives you hope?
Let's see. I think that I agree entirely with Susan that if we really want to change the numbers of people incarcerated, it's about violence. And for a long time, the argument has been, well, we have all of these drug offenders, all of these nonviolent offenders in prison, and that was more true than it is today. Certainly in California, it's about violence. It's about homicide primarily. And we have to confront our ideas about that as a public. And I think there is some start about that. I would like to see us have a larger discussion about violence and a way in which we can talk about that more honestly and straightforwardly. We have a culture that's very pro-violence, and then we treat it in extreme ways in the system. I do see that the parole system is starting to get that better, but we probably do need a larger mechanism there. I also see some hope on the entry-level side. I do a lot of work in jail, and certainly there is more in the way of diversion of cases, particularly with respect to mental illness. Now, the mental illness factor, as Susan mentioned, is a complicated one. It's not exactly what we expect. You see somebody with schizophrenia, and they've attacked someone at a restaurant, and it's got to be the schizophrenia, and sometimes it is, but oftentimes it's more complicated than that. What turns out, we know for sure, is that basically the same social factors, same incredible stressors that tend to give people in one community more likelihood of becoming criminal offenders are also the same factors that will produce some very significant mental illness. So the two go together along with substance abuse, so that they're like this great trio. And the extent to which we can start to say, well, let's disentangle this a little bit. And if we can somehow start to address the traumas that have produced both the mental illness and the criminal behavior, then maybe we start to get somewhere, as long as we're really realistic about this, which is that it's not just give this person a good therapist and everything's going to work out. It's a complicated picture. But if we can start to say, well, we do have this situation here where, we've got a robbery case. I was talking to a guy in jail the other day, and he's looking at a 3-strike life sentence. He's 58, and he's got a robbery case. And the robbery case involves, I hope I'm not mixing up two people, but even if I am, it's not an atypical situation. The robbery case, no, okay, that was a different one. Just stick on the robbery case where robbery is he's stealing beer, liquor from a store, This clerk tries to stop him. He's got a knife with him because he was threatened the day before. He gets out the knife. It's a robbery. That's a 211. And now it's a major felony, and he's in the county jail in HOH, high observation housing, which means he's got a major mental illness or depression makes him suicidal. Let's unpack this. Let's unpack this. Let's not just say it's a 211, it's a violent crime, he's got a past 211 or a past violent, and therefore he's got to do this. Let's unpack this and say, okay, where is this person? What is it that is going to put him in these conflict situations? Yes, there's behavioral stuff that needs to be addressed. Why is it that in this situation you really felt a need to pull out the knife when he was just trying to stop you from taking this liquor? I mean, you knew you weren't supposed to do it. So there's a whole set of things there. There's interest. I think there's public support in trying to do things in a different way, and we now just got to figure out, are we going to put the real resources into doing it, and also look hard at these programs. Some will work and some won't, and let's make sure that we maximize the ones that work and not the ones that don't, so that we don't just make a global decision, which is usually what we do. That didn't work, right? Well, that piece of it didn't work, so let's be a little more sensible about it.
And just to step into your example a little,
Yeah.
One day prior, right?
Yeah.
So he had been threatened, so
Right.
there's context as well, and his solution to that threat was to carry the knife.
Right.
So
Right, and this is also what I mean about social setting, context, community. Most of us don't live in neighborhoods where we feel like if there's going to be a conflict, we need to have a knife. But there are places where that actually is not such a crazy decision. I think it's a bad decision in almost all cases. I can give you the arguments why. You probably know those. But if you live in a place where you're likely to be hassled, and you've been victimized before, and you know that you're not going to be able to do it without a weapon to protect yourself, right? So that's a part of that picture, and part of addressing that should be not just to punish for the threatened violence, but to say, well, let's back this off. You know, so why did you get into a place where you think that you have to have a knife? And has that really done you any good? And can we start to de-escalate that violence in terms of both conduct and in terms of culture?
So on the front end of a crime committed, alleged crime committed, it seems to me all these things are mediated by the district attorney and the public defender. On the back end, if the person is in prison, it's mediated by the parole board. And I think the work that you're doing, both of you, is really marvelous to infuse those entities with information that can be helpful. My experience, limited though it is that it's not. That the criteria on which district attorneys proceed in the charging part and then the negotiation plea bargaining part is not connected to any of that stuff. It's all connected to the crime itself. On the back end, on the parole board, all it takes is a vociferous district attorney who charged the original crime 20 years ago come in and say, this guy's a freak, right? And it's going to skew the deliberations of the parole board relative to this person. He may be the most rehabilitated person you want to meet, but the original charging district attorney is there to say he's an animal, and it skews everything. Is there a way of fitting into your respective models education of the people on the front line?
Oof.
Go for it, Susan.
I mean, that's kind of that's the sticking point, because the power now, particularly with determinate sentencing, which, you know, most of our stuff in California is determinate, is the charge of it, how it gets charged. And I think they must be the hardest nut to crack. I mean, the people in probation and even the Department of Corrections, they've got the people, they've got to figure out how to deal with them, and so that in some ways more positive. But their outcome, it's the whole system. The justice system has these outcomes, and their little notches on their lipstick case are different. And prosecution is like, they don't play this game.
So let me jump in for a second as a former prosecutor and as a legal educator. So I'm educating students, some of whom will become prosecutors and defenders. I think that there's several issues. One is that I'm hoping that the next generation of change will occur in a little bit of a mindset within the legal system for us to become less adversarial. That's very difficult. It's very essential to the system that we have an adversarial system. But an awful lot of what we do in criminal justice is actually not adversarial in the traditional way. It's negotiated. Most cases are negotiated. And that should be, and now they're being negotiated on different terms. So, for example, my students have informed me, like for the diversion program in LA County, there's like one DA that is like the gatekeeper on this and is making all of the decisions. That's crazy. That's crazy. And the other piece about this is that, you know, we actually represent the two basic academic divides in criminal justice. We almost never talk to each other. We have very different, you know, you have a different career path than I have. And the people who go into these things are very different. We need to talk to each other. So one of the things, for example, that I'm always talking to my students about, I always say, do you know about the age crime curve? Do you know about the age crime curve? And it's one of the most robust findings in all of criminology, and most lawyers don't know it. I mean, they'd be able to say, yeah, it's true, basically, you know, teenagers get in more trouble than anybody else. But actually, no, this curve, and the curve starts coming down, you know, around 17 or 18, maybe even earlier. That's big, and it makes nonsense of a lot of the life terms that we're giving out, both 3 strikes and even for homicide. We need to get a place where the prosecutors particularly are better educated about that social science of criminology. I think prosecutors and defense attorneys need to be much better educated about all of the behavioral science that goes in. Developmental issues and all of the major mental illnesses and all of this stuff, because prosecutors are making judicial decisions all the time. And they're making these decisions that should be informed by things other than the crime of conviction. They're not. Defense attorneys aren't always that much better in terms of playing the game on a broader scale. So all of these things are really important for us to kind of reimagine what it means to be a prosecutor, a defense attorney, a parole board member, and that imagination is a big part of that change process.
I have one point. The idea of what's referred to as therapeutic jurisprudence, which I can half the time say and half the time can't, is actually getting more in the system, meaning there's a big, more emphasis on drug courts or mental health courts, specialty courts that bring in the partners, and the partners decide whether or not a particular individual can maybe have a diversion and complete more of a treatment kind of program, which has a more collegial kind of, I think, group kind of positive view of things. So I think that has changed. I mean, I've been doing that since the 90s. And I see that with the prosecutors, and the prosecutors and the public defenders need to buy into these kinds of, and there's young adult courts trying to take, you know, into consideration that your brain isn't really developed till you're 25 years old. So if you put in a 16, you bump them up and they go in for, you know, 20 years, you're really, it's not very efficient either, because you're paying for all this stuff where a person's not going to be committing crime. I think that's helpful, and certainly particularly with the mental health education, I think is real important. We're both teaching a course with mental health in the justice system. So I see those inroads. And the interesting thing about this therapeutic jurisprudence, it's not the prosecutors who are often the most difficult ones to convince about this kind of model. Who's the most difficult? It's the public defenders, because they play the game. They think, this is very simplistic, I'm not an attorney and don't play one on TV, but there's always the possibility, I think, from, at least when I have these discussions, from the public defender's point of view, that this person will get off. And so if they make an arrangement to be on some kind of thing that may take them in treatment and their supervision, that they're saying, no, don't take it. So let's try to see if we're going to win with the dice. So it's interesting who are more open to some of these alternative therapeutic jurisprudence than others in the system. So
our time is up. While we were having coffee before we came up here, we noted that the society that we're enduring these days is so deeply divided, and one of the griefs is that people don't talk to one another, especially people that have different perspectives, different views of things. They really don't engage. So this has been a wonderful opportunity to not only have a great conversation, very rich and complex and deep, that'll cause us to keep thinking about these things, but also I think it models what we need a lot more of just every day in our society. Thank you very much, Professor Turner, Professor Pillsbury, and thank you to all of you.
Thank you, Scott.
We're adjourned.